Welcome back to the Constitutional Clarion. Today I'm going to talk about constitutional recognition and the voice. Are they two separate things or are they the one thing? Could we have them in two separate questions? This is something that's often raised in letters to the newspaper and in comments by people on Talkback Radio. They say, look, I support Indigenous constitutional recognition, so I want Australia's Aboriginal and Torres Strait Islander peoples to be recognised in the Constitution, but I'm not so keen on the idea of the voice. I'm wary about it. Why can't we have two questions in the referendum, one about recognition and the other about the voice? The problem with that proposition is that you then need to ask people, well, what do you mean by recognition? How are you going to do that? And they tend to say, oh, that's okay, we'll just put some words in the preamble in the Constitution. Now, from a constitutional lawyer's point of view, that raises a bit of a red flag because we don't actually have a preamble in the Constitution. What we do have is a preamble in the British Act of Parliament that was passed in 1900, which contains our Constitution as Section 9 of that British Act. But our Constitution itself doesn't start with a preamble, it starts with the very romantic Table of Contents. Okay, so we don't have a preamble in the Constitution. And frankly, it would be completely bonkers for Australia now to try and change the historic preamble in the British Act of Parliament. I mean, what that preamble says is that the various colonies came together to form one indissoluble federal commonwealth under the Crown of the United Kingdom and under the Constitution. Does it make a lot of sense to try and retrospectively change that statement of history to say, and by the way, we recognise Australia's Aboriginal and Torres Strait Islander peoples, even though we didn't actually when this act was passed by the British Parliament? It's all a bit crazy. So in reality, what people are talking about is, well, maybe we should put a new preamble into our Constitution. And that's what John Howard proposed back in 1999. So you might remember in 1999 there was a Republic referendum, but there was also a second referendum that Prime Minister Howard proposed, and that was to put a preamble into the Constitution, regardless of whether the Republic referendum won or not. Now, there were some problems with that, and the first problem was, well, if you put in a preamble, it's not just going to say that we recognise Australia's Aboriginal and Torres Strait Islander peoples, but you're going to end up having to put on other stuff in there as well. And that's where huge amount of debate tends to arise and a lot of argument about what terminology you use, whether or not you recognise different groups, and what kinds of statements do you make about what's important to Australia. You know, do you talk about equality and fairness and the rule of law and all those sorts of things? And then what are the possible implications from interpretation of the preamble? So we had all that fight back in 1999, and the preamble referendum was actually even less successful than the referendum proposal on a republic. So understandably, Australia's Indigenous people don't really want to have that kind of broader fight in relation to recognition of Aboriginal and Torres Strait Islander peoples. All it would do is it would explode the fight out bigger and make it even more difficult to succeed. The second reason for not putting this kind of recognition into a preamble is that sticking words on the page of the Constitution actually doesn't achieve a lot. And we know that. We've got evidence of that because every single state constitution now recognises its Aboriginal or Aboriginal and Torres Strait Islander peoples. But the population doesn't actually really know that. I'm pretty much betting that anyone watching this video, most of you anyway, didn't know there was already constitutional recognition in the state constitution. And frankly, most of you didn't know there was a state constitution at all, did you? Okay. So doing that's not really very effective. It just doesn't achieve anything. The third point is that it's also not the kind of recognition that Aboriginal and Torres Strait Islander people have asked for or want. And that's actually quite important because if you're going to recognise a particular group in your constitution, you need to recognise them in terms that they want to be recognised, because otherwise people, when they're voting in a referendum, will say, well, Why am I doing that? Why would I vote for it if the people who are being recognised don't want to be recognised in those terms? Then the whole point of it is rather futile. And that also was reflected back in 1999, where you might remember there was a particularly virulent argument about the terminology used for the recognition of Aboriginal and Torres Strait Islander peoples, which resulted in quite a number of Aboriginal groups opposing the preamble and probably contributed to the failure of that referendum question. So just sticking some words in the preamble to the Constitution, not terribly useful. The third point to make here is that the type of recognition that Indigenous people asked for when they were consulted, which they were through the Referendum Council and resulting in the Uluru Statement from the Heart, was that they wanted recognition through a voice to Parliament. So it's the voice itself which is the form of recognition. Now, why is this a better form of recognition in their view? Well, it's more than just words on the page. It's something continuing and active because the recognition occurs by listening to the voices of Indigenous people and paying them that respect by giving them that attention. So let's think of this for a moment in terms of another example. Say you were worried about your local council and how they were dealing with a particular issue and you wanted them to change course. Now, would it help you at all to be recognised by the local council by having your name on a list of ratepayers? Well, no, it's not going to achieve anything at all, is it? However, if you go to your local council meeting and the chair of the local council recognises you and says, I recognise so-and-so there in the audience, and that gives you the opportunity to stand up and be heard, what happens then? Well, you have the opportunity to seek to persuade the council to change course, to change its policy. You can better inform it so that it can make a better informed decision. Now, you can't demand, you can't make sure that they definitely will do what you want, but you might well succeed in what you're after by persuading them that you actually have a good argument, that the evidence supports your view and that they should take into account the matters that you've raised. And through that, the kind of recognition that you were given by the chair is much more effective than just some words on a page. And it's for that reason that Indigenous people want to be recognised in the Constitution by the establishment of a voice so that they can actually achieve something. Achieving it not by demands or vetoes, but by simply being able to influence, by better informing Parliament and the Executive in the decisions that they make that affect Aboriginal and Torres Strait Islander peoples. So, coming back to the original question of why don't we have two different questions on the referendum paper, one for recognition and one for a voice, it is the voice itself that is the recognition. The recognition comes every time the voice is listened to, every time Indigenous people are given that respect of being heard. It's not just words on the page, it's something that may, and hopefully will, achieve useful outcomes, and it's a continuing and active recognition. The recognition happens every time the voice is heard, and that's what the proposal is trying to achieve. I hope that's a useful explanation for you, and I look forward to seeing you next time on the Constitutional Clarion. Goodbye.